Hello, everybody. This is Fair Housing Advocates once again with a short Fair Housing 101 series webinar. Can a city, county, or local municipality or any government here in America ban a service dog or an emotional support animal or assistance animal from housing because of its breed, or really because of its breed, weight, size, for whatever reason? Well, we know from HUD, breed, size, and weight limitations may not be applied to an assistance animal. That's pretty straightforward. But are they also talking about cities that may have bans on a certain breed? So most people, well, I would think all people who have an assistance animal, a service dog, an emotional support animal, they're in the business really of asking for a reasonable accommodation. So if there is an apartment complex that says, well, we don't accept German Shepherds or dogs over 45 pounds, and you have a 60-pound German Shepherd, that you're going to have to ask for a reasonable accommodation because you're a disabled person who requires that animal. So what is a reasonable accommodation? It's a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. The Act makes it unlawful to refuse to make reasonable accommodations to rules, policies, practices, or services when such accommodations may be necessary to afford persons with disabilities an equal opportunity to use and enjoy a dwelling. So this comes straight from HUD. But does it apply to a city, a town that may have some sort of ordinance? Let's talk about the assistance animal. We've mentioned the word assistance animal a few times. An assistance animal is not a pet. It is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effects of a person's disability. Now, you can hit pause here and read the rest of the screen, but if you've already picked it up, an assistance animal is a service animal and an emotional support animal. It's all of those things. So the assistance animal term is an umbrella term for really any sort of animal that provides the assistance, provides emotional support, so an emotional support animal, or a service animal. So as we saw earlier, and I'm not one to typically bounce around here, but let's go back up. Breed, size, and weight limitations may not be applied to an assistance animal. So let's continue. So who is liable under the Fair Housing Act? According to the Department of HUD and the Department of Justice, HUD being Housing and Urban Development, any person or entity engaged in prohibited conduct may be held liable unless they fall within an exception to the Act's coverage. I can tell you right now that the city's not going to fall within that exception. So refusing to make reasonable accommodation, rules, policies, practices, or services when such accommodations may be necessary for a person with a disability and equal opportunity to enjoy a dwelling may be held liable unless they fall within an exception. Coming straight from HUD and DOJ. So any person or entity. And for those attorneys out there and others who like, to cite cases, there's plenty of cases out there, but two of the most famous are City of Edmonds versus Oxford House and Project Life versus Glendenning. You can hit pause, look at that, do your little research, and you can find out that no city, no state, no local government, municipality can really escape the Fair Housing Act at all. Well, Patrick, what about public housing? Right? Well, that's true. Okay, so you can have a city, a county, whatever it may be, that owns a particular building, right? So it's public housing. So aren't they governed by the ADA and not the Fair Housing Act? And what about those? What about those kinds of entities? So the definition of a service animal contained in ADA regulations does not limit housing providers' obligations to grant reasonable accommodation requests for assistance animals in housing under either the Fair Housing Act or Section 504. So no matter what kind of entity you may be, if you're providing public housing or that you fail or refuse to provide a reasonable accommodation that is necessary for a disabled person to enjoy the benefits of fair housing, you're still within the scope of the Fair Housing Act. In fact, and we have a couple cases right now against some cities in this country in 2 different states where they're citing the ADA. Not sure why, but as a defense, saying, well, the disabled person's animal is an emotional support animal. It's not a service dog, and therefore we don't have to provide a request. It's something that's not a service dog. Well, any public entity or public accommodations that operate housing facilities may not use the ADA definition of a service animal as a justification for reducing the Fair Housing Act obligation. So using the ADA definition when you may be an ADA covered entity, you cannot use the ADA definition of a service animal even as a defense. So you're not escaping the Fair Housing Act. So who should be provided an accommodation request? Really 2 simple things to consider. And I'm always citing at the bottom or somewhere here on the page where FEHA Notice 2013-01. Does the person seeking to use and live with the animal have a disability? Question number 1. Question number 2, does the person making the request have a disability-related need for the animal? So does the need have everything to do with their disability and addressing the disability? So, in other words, does the animal work, provide assistance, perform tasks or services for the benefit of a person with a disability, or provide emotional support that alleviates one or more of the identified symptoms or effects of the person's existing disability? So does the animal alleviate one of the symptoms of the disability? So if you have problems walking, the dog should help you walk. If you have problems sleeping, which is a daily life activity, then the dog better help you sleep. So there should be a disability-related need for the animal, and it is an assistance animal. Well, when can it be denied? Because if a city is just like any other entity or person is subject to the Fair Housing Act, is there a time where maybe accommodation requests can be denied? Well, of course. If the specific assistance animal poses a direct threat to the health or safety of others. So, if I had an emotional support tiger, I'm sure that might be okay on my 20-acre farm in Montana. But if I have an emotional support tiger and I want to live in an apartment complex, I think it would be pretty easy to argue that it may pose a direct threat to the health or safety of others. And then number 2, specific assistance animal in question would cause substantial physical damage to the property of others. I've heard of cases where there is an emotional support, maybe miniature horse or pony. Would that cause substantial physical damage to maybe a small one-room unit or maybe a small apartment complex? It could. And one could make that argument. And of course, if I can make something fun, I will. Can the accommodation request be denied? Number 3, the accommodation would impose an undue financial burden or to fundamentally alter the nature of the housing provider's services. So here's an actual elephant, muffin top, that was registered with this Emotional Support Animal Registration of America, which is, as we discussed in other webinars, not necessary for any reason whatsoever, but it's just kind of funny that we could actually register an African elephant as an emotional support animal. So would having an African elephant cause undue financial burden? Absolutely. Would it fundamentally alter the nature of a housing provider's services? Absolutely. If an apartment complex, condo association, HOA was then given the responsibility of housing an elephant, taking care of an elephant, or cleaning up after the elephant, or accommodating this elephant, that you're now changing what they do. Instead of providing just housing, now they're providing other services and other things to make do for an elephant. And of course, number 4, if the request was not made by or on behalf of a person with a disability, or if there's no disability-related need for the accommodation. This is simple. If you're disabled and need an accommodation request, you don't ask for it, they don't have to give it to you. Or if there's no disability-related need for the accommodation, if my disability is I can't walk, a major life activity, walking, seeing, hearing, thinking, sleeping, any of those things, if I have problems walking and my so-called assistance animal knows how to fetch the remote control and other tasks, that has nothing to do with it helping me to walk. So there's no disability-related need for that animal and that accommodation. Now, we mentioned this earlier, and I kind of purposely passed by it, but the request can be denied if the specific assistance animal I highlighted pose a direct threat, or a specific assistance animal would cause substantial physical damage. So it's about the specific animal, right? So a determination of assistance animal poses a direct threat of harm to others would cause substantial physical damage to the property values must be based on an individualized assessment that relies on objective evidence about the specific animal's conduct, that animal, that specific dog, not on mere speculation or fear about the types of harm or damage an animal may cause, and not on evidence about harm or damage to other animals of the cause. So if you bring your dog, Fido, and that is your assistance animal, and your assistance animal is a half wolf, half pit bull, or whatever it may be, and it's a bona fide assistance animal, provides assistance that directly addresses one of the symptoms of your actual disability, okay? And provided that that individual animal hasn't obviously posing a direct threat to anyone, isn't biting anyone, right? They can't just on mere speculation, well, we don't like the pit bull breed, or pit bulls are dangerous. That's speculation. It's not based on that specific animal, Fido, your dog that you brought with you. So it can't be based on breed or speculation or fear. It has to be based on your specific animal. If they have no history with that animal, then they cannot make an individualized assessment, period. So there'd be no reason to ban that dog based on anything, let alone breed. Here's an example of a city that has an ordinance against, looks like pit bulls at the bottom, Staffordshire Terrier, American Pit Bull, American Staffordshire Terrier breed, or any breed that has the appearance of these kinds of dogs. So is there anything wrong with that kind of breed ban? No, not under the Fair Housing Act there isn't, as long as they don't apply it to assistance animals. But looking at this, is this based in fear about a breed, right? Is there speculation involved? So it can't be based on mere speculation or fear, right? So you can't apply this red square here to your particular assistance animal, right? Because they have no individualized assessment. They never maybe they never met your dog. So there's nothing wrong with the pit bull ban, let's say, per se. Those don't apply it to your animal. Something's up very quickly here as we're wrapping things up. So are you or a family member a victim of discrimination? So if any of these things that are brought to your attention seem familiar, or any of these things I'm about to say seem familiar, you may be a victim of housing discrimination, and we can help. So if a city or county is prohibiting your assistance animal from living with you, and remember, the assistance animal is an emotional support animal and is a service animal, usually a dog, right? So if a city or county, we'll just say government, is prohibiting your assistance animal from living with you within city or county limits, or prohibiting your assistance animal from walking, enjoying, using, the property. So, okay, we'll let you live within our city limits, but you have to have the dog in your yard only or in your house only. That's a problem. If you're being threatened with fines because of your assistance animal, or being threatened with the removal of your assistance animal by the government, is a landlord prohibiting your assistance animal from living with you, or from using the property, or from visiting others who live on the property? Is your apartment, condo association, mobile home park, or homeowners association prohibiting your assistance animal from using the common areas? Clubhouse, pool area, theater, library, cafeteria, whatever it is that's on campus there, or prohibiting your assistance animal from living with you. So if any of these things I've mentioned seem familiar to you, or you've heard of others going through this, they may be really a victim of discrimination. Now, on the basis of what? On the basis of disability. Because if you need an assistance animal, it's likely what you need it for, or it's the only reason you would need it. So again, if any of those things sound familiar with you, you may want to consider filing a fair housing complaint. Never done it before? Not a problem. Most people have not. Fair Housing Advocates, Incorporated, my firm, is a nonprofit civil rights firm dedicated to helping any victim of housing discrimination defend or establish their fair housing civil rights on the basis of their protected class. We're really talking about the protected class, disability, but we'll help anyone on the basis of any protected class. All of our services are at no cost. Counseling, advocacy, we help write the complaint for you, with you, create and gather evidence, file the complaint, assist with any HUD interviews, U.S. Department of Housing and Urban Development. That's where a fair housing complaint is sent. And they're the ones that execute the Fair Housing Act and the fair housing complaint process. So we help with those interviews and communications, assist in negotiation of a settlement for you if you're the victim. We provide all the testing and investigations to produce evidence if we need to support your case, all at no cost. All of our education outreach, just like this little webinar here, we can customize a very big webinar for your organization. If you're part of a PTSD organization, a disabled veterans organization, that's who we want to work with. We'll host all the online webinars, customized webinars for your organization, seminars, workshops, advice hotline. We're putting up a new advice hotline. It's a toll-free number. Joint effort, customized multimedia presentations and education materials. We'll work with you or your organization to develop materials just like this. It may be passed out, emailed, shared. And, of course, any kind of fair housing training. Any questions or interest, you can visit our website at www.fairhousingact.org or send us an email with your questions or requests at info@fairhousingact.org. Either one, I definitely recommend you visit the website. Any questions, need help, reach us at info@fairhousingact.org. Be more than happy to help you. And we are a nonprofit. We will do that at no cost. Thank you very much.